A very good morning to all of you. I hope you all are fine during this COVID-19 situation. Today we are organizing an webinar on the topic of Corona Relax IBC, a phase saver for Indian corporates. So today we have with us a very special guest that is Mr. Dr. R.S. Solanki. So let me introduce to all of you. Dr. R.S. Solanki is currently working as an associate professor, Faculty of Law, Jamnalal Bajaj School of Legal Studies, Banstali Vidyapeeth. He has also worked as assistant professor, teaching assistant, and guest faculty at various prestigious institutes such as Faculty of Law, Modi University, Seedling School of Law and Governance, Jaipur National University, National Law University, Jodhpur, and University College of Law, Mohanlal Sogadia University. Along with this, he has advocacy experience of 8 years in district courts and high courts of Rajasthan, Jodhpur from 1998 to 2006. He authored various books such as Banking Law by Satyam Law International, New Delhi, then Insurance Sector Reforms and Regulations by Lombard Publication, Germany 2015, and Law and Financial Sector Reforms by Regal Publications, New Delhi. He chaired various seminars, attended various conferences, and judged various moot courts at national level. He is also acting as editor and editorial board member for various national and international journals. So this is just a small introduction. He has a long list of achievements. So thank you, sir, first of all, giving your valuable time for this session. Now I hand over
Thank you, Varun.
this to you. Yes, and now you can continue the session.
Okay. So, a very warm good morning to all the participants. And as we know that it is really a tough time for all of us that we have to assemble like this during the corona pandemic. So, although it would have been much better if we could have a live or with physical things like seminar and all that, but since in the corona pandemic that cannot be done, obviously it is also one of the way to get connected with you all. So let me first briefly introduce the theme of this webinar. First of all, this word webinar also seems to be something with which we were not well acquainted prior to COVID-19. So that is again a very new thing for all of us. All we were having that was seminar, and now just see how the things have changed in last 3 or 4 months. Instead of seminar, now it is a trend for a webinar. So anyway, that is a good change. We can see, we can connect with each other by way of this. So as far as the theme of this webinar is concerned, all of us, we know that because of this corona pandemic, there is a heavy toll on the economy. All the sectors of the economy, they are completely ruined or washed out. And really, it is very difficult for the economy to survive amid corona. And again, the biggest worry we can see or analyze, foresee, that is nobody knows. Nobody means even the medical experts, WHO, or even the government, anybody, anywhere in the world, nobody knows that till what time this pandemic will be there. So now the thing is that we should know how to be with corona, how to live with this corona pandemic. And because of that, obviously now we will have to live with this corona. The only thing, the message, although obviously you must be knowing, stay at home, stay safe, and be regular with your studies or whatever work which you are doing. Now, coming to the theme, we can say that because of this corona, there is a heavy effect on the overall economy. And because of that, the government of India had taken so many measures, we can say, besides providing the economic package of 20 lakh crore to the industry. One of the things, as far as our sector is concerned, the field of law, they have done various amendments in the law. They have made so many changes in the Income Tax Act, company law, and as far as our topic for today, IBC also, that is Insolvency and Bankruptcy Code. So the thing is, although IBC is not a very old legislation, it came into existence in 2016. And in very few years, you can see in 2020, there is always, whenever you talk about the financial sector, our talk is not completed when you don't mention about insolvency and bankruptcy. So the thing is that because of this, in very short words, or in a layman language, what we can understand, that because of these insolvency laws, uh, the banks and financial institutions, they were now able to get their loans back, and there was a very fast recovery of the loans. But because of corona, again the problem which we are facing now, that is, now if we allow the IBC without these amendments, then since the economy is in recession, business are not being run on proper scale. That is why the corporate sector is now in big trouble, and it is very difficult for them to repay the loan which they have taken. Now the thing is, if we go with the IBC without these amendments, then there are heavy chances that all the companies and factories and MSMEs and all that, they are going to shut down if we go with the proceedings of insolvency and bankruptcy. And we cannot do that for the obvious reason that in the economy, it is very important for all of us, that is revival or survival of the corporate sector. Without them, obviously economy cannot survive. And that is why the government did some changes in the insolvency and bankruptcy code. They announced a few of the things very early. I think during the first lockdown itself, around 22 or 25 March, and later on 5th of June, they came up with an ordinance, and by way of ordinance, they have made suitable changes, because of which right now nobody can drag the corporates uh, to the court or tribunal, even if they fail to repay their loan amount. And at this stage, we can say that it is completely fair also, because we know how much difficult it is to run the business nowadays, because many of them, they are not getting the labor, many of them, they are not getting the supplies of the raw materials, employees are not working properly, all these kind of things, lockdown still it is in the country. And that is why right now at this stage, it seems to be quite fair that government has relaxed the IBC norms for corporate sector. And that is why right now this relaxation in IBC, it seems to be a face saver for the Indian corporates. So Varun, can you show me the slide now?
Yes, sir.
Okay. So yes, thank you, Varun.
Welcome, sir.
This is the first slide that is which talks about our topic for today. That is Corona relaxed IBC, a face saver for Indian corporates. The thing with which we just talked about. Yes, next please. Okay, yes. So now starting with the meaning of insolvency and bankruptcy, and then the historical background. The first thing is that for a layman, as such, there is no difference. Means they don't understand what is the difference between insolvency and bankruptcy. And many times the people, they are often confused that what is the difference between, is there at all any difference between insolvency and bankruptcy, or are they same? The first point is that certainly yes, there is a difference between insolvency and bankruptcy. For insolvency, means I am just putting it in very simple words without any going into the legal and technicalities of these two words. Even if we just go by the dictionary meaning of these words to understand in very simple words, as far as insolvency is concerned, it is a stage of for an individual or partners or corporates whereby their liabilities, they are exceeding their assets. And as we know that when they prepare their balance sheet, there are always two sides: assets on one side, liabilities on other. And when the liabilities exceeds the asset, then we can say that yes, something, there is a sign of trouble for that individual or corporate business. For obviously, because the signs are very clear that since their liabilities are exceeding, because of which they are facing some crisis regarding payment, whether it is payment of dues to the government, whether it is payment due to their suppliers, whether it is regarding the salary to their employees, or obviously when they are failing to repay their loan amount. So we can say that it is the beginning of uh, the things which are going to come, that is regarding how they are going to pay their debts and all that payments. So at this stage, as such, the courts and the government has nothing to do. They are becoming insolvent, and this is the stage which sets the platform for bankruptcy. Because once they are insolvent, only then bankruptcy will come into picture, whereby uh, in a sense we can say that there is a official or legal recognition that this person, individual, partner, or corporate, that has become insolvent, and now formally it is to be declared by the competent authority that this business has now become bankrupt. Insolvent they are, but whether they are bankrupt or not, that is yet to be decided. And for that, someone will have to drag that business to any tribunal or court to have an official declaration that they are insolvent. Now they should be declared bankrupt. So, to sum up these two words, we can say insolvency again simply means that their liabilities exceed the assets. Bankruptcy simply it means that there is official recognition to the fact that business has become insolvent. That is obviously, of course, by the courts and tribunals. Now, the next question which comes into our mind, that why we need to have a difference between the two things, insolvency and bankruptcy, or why any insolvent person or a business, they will want themselves to be declared bankrupt by the court. Out of the so many reason, one of the reason we can say uh, that uh, of course the third parties, they can always go uh, for recovery of their dues against that failed business, and for that they will have to knock the door, by taking the help of various laws. Earlier, it was Recovery of Debt Due to Bank Act 1993. Then came SARFAESI Act 2002. Now it is Insolvency and Bankruptcy Code. So they have to take the help of these laws. They knock the door of the court and they want their money back. And this is the reason the third parties, obviously they will go to the court, that is to declare that insolvent business to be a bankrupt one, so that we can initiate the proceedings under the relevant law, and the person, all the stakeholders, whether it is government or employee or the creditors, suppliers, they can get their money back. And this is the reason they are going to be there for declaring that insolvent business to be a bankrupt one. So that is the reason someone will go to declare an insolvent business to be a bankrupt one. Now, one of the most prominent feature, although we can have a discussion later on also, but just keeping in reference right now at this stage, the specialty, one of the specialty of insolvency code, we can also say that is, it is not only the third parties, that is the outsiders to the business who are allowed to go for the bankruptcy proceedings, but at the same time, the person, the insolvent person himself, he can also go to the court to declare himself as bankrupt. Now, remember, he is an insolvent and he himself wants to be declared as bankrupt. What is the reason? What benefit he is going to get from there? Obviously, means even we also wonder that why he himself wants his own business to be bankrupt. The reason is that till he is insolvent, he will be always facing the trouble. Many times it might be that his business is going to be wind up, proceedings will be so many proceedings, there will be in the court, business may be shut down, and unless and until he comes out of the situation, he will not be able to even start a new business and all that. And that is why many times the corporate debtor, the insolvent one, they themselves also prefer to go for the declaration of bankruptcy, whereby they can knock the door of the tribunal, the court, they get themselves declared to be a bankrupt one. And because of that, what happens that this IBC gives them a solution whereby there are fair chances of its business to revive back. That is, he can save his business also, and at the same time, all the creditors, suppliers, stakeholders, they can also get their money back. And that is how they go for this resolution. And this is the reason that the insolvent person wants to knock the door of the court. Now, once he goes for that, obviously his business might survive, creditors can get their money back, and that is why they also prefer, that is the insolvent corporate debtor who has taken the loan, they can also knock the door of the tribunal or court to get themselves bankrupt. So this is the reason when we go into the detail of this aspect, we will see that even the corporate debtor himself is also allowed to file the application for insolvency proceeding, corporate CIRP, that is Corporate Insolvency Resolution Plan. So now coming to the next thing, that was the little bit idea about insolvency and bankruptcy. Now, as far as the historical background of the recovery laws of India is concerned, especially the insolvency laws, before coming of Britishers, as what happened in most of the law, we all know that even IPC came in 1860. So as such, there was no law in India regarding rest of the field. Same case was there for insolvency also. So as such, there was no law regarding insolvency prior to the arrival of Britishers in India. Now, when the Britishers they arrived in India, English law came into existence for the first time in India. So many legislations were drafted. You can see the criminal law, evidence, IPC, and all that. And because of that, something started to happen in case of law of insolvency also. And the first sign of insolvency law we can trace out in history uh, when we see the situation of the presidency towns during the British era. These presidency town, if you don't know much about these were the towns, the prominent towns of trade and commerce during the British era. That is Bombay, Calcutta, and Madras. So at these presidency towns, the British were having their trade and commerce activities. They were at its peak. Means these were the areas where the trade was centralized, we can say, during that time. And that is why seeing the importance of trade and commerce activity during that time, uh, the Britishers came with the first act regarding insolvency. That was Presidency Towns Insolvency Act of 1909. So the first act regarding insolvency, if we talk about, that is your Presidency Town Insolvency Act of 1909. Later on, when they saw the trade has also started in non-presidency towns, that was popularly known as Mofussil area at that time. That is the area which was not part of presidency towns, obviously, which was not part of Bombay, Calcutta, and Madras. That is rest of India. That was regarded as Mofussil towns. And in these Mofussil towns also, they came up with one separate law, that is Provincial Insolvency Act of 1920. So these were the two laws regarding insolvency during the British era. That is, for presidency towns, we were having a separate law, Presidency Town Insolvency Act 1909, and for Mofussil areas, that is rest of India, non-presidency towns area, we were having Provincial Insolvency Act of 1920. Now coming to the next part of the history, after independence, if we refer, all of us, we know that 1991 was a landmark year in Indian economic history, because that was the year when we opened the door of our economy for the outsiders. Uh, Little briefly, if we talk about why these reforms of 1991 were done, the most important thing that was, we were under such a crisis, financial crisis and balance of payment crisis, that we were not having any foreign reserves, and the position was that India had to mortgage the gold reserves, and one plane was sent to Britain to mortgage the gold and to get the foreign reserves. So that was the time because of which, or we can say, which paved the way for economic reforms in the country, headed by Prime Minister Mr. P.V. Narasimha Rao, and the finance minister at that time, the former Prime Minister Manmohan Singh ji. So they started the economic reforms of the country. The financial sector that was being opened, economy was opened, and in a sense, we can say that was the end of license Raj or permit Raj. and most of the sectors gradually they were being opened for the private players, not only the private players but for global players also. And that is why today we see many areas of the economy which were completely out of the scope for reforms. Even in the defense also now we are having the entry of the private players. So the point is, because of these reforms, overall reforms, whether it was your banking sector, whether it was your insurance sector, whether it was your pension sector, all the sector, mutual fund, NBFCs, everywhere there was a reform. And because of that, the trade, it obviously you can see the statistics also, what was the position of economy prior to 1991 and post 91 and now in 2020. So because of that, because of the heavy growth of trade and commerce and opening up of all the sectors, so many changes were done in the laws in various fields. And uh, because of that, since our business became global also, that is, many of the multinational giants, they came in India. Many of the Indian companies, they went abroad. They are also MNCs. You can see many of our Indian companies, their takeovers and acquisitions abroad. And because of so much flourishing of the trade and commerce, uh, government started thinking uh, regarding the recovery of the loan which is given to these companies. Now, obviously, when any trade or business that is growing, they always need the money. When they take the loan, many times it has been seen that they are unable to pay their debts, their loans. And because of that, earlier they came up with the recovery of debt due to banks and Financial Institutions Act, RDDB FI in 1993, that was regarding the establishment of tribunals for recovery of the loan. But after some time, after 2 or 3 years, this system also did not work, and the tribunals, they were flooded with the recovery matters. And again, government in 2002 they came up with the Surface Act, that was also regarding the recovery of the loans and reconstruction of the security interest and all that. And later on, since from these DRTs and from Surface I also, uh, the banks were still, and the lending institution, they were still facing the trouble regarding the recovery of loans. They were not able to get back their loans because of the nature of these legislations. And that is why government again thought to have one more law uh, regarding the recovery, and that kind of law which not only deals with the recovery of the loans, but at the same time they also give an opportunity for these business houses to firstly go for revival of their business. Because again I am repeating, just shutting the doors of any business just because they are unable to pay the debts is not a good solution for any economy. We should always have that kind of approach where the lenders get back their money. At the same time, the business is also given a fair opportunity to revive themselves. And that is why uh, on 22nd August 2014, Government of India, they set up a commission. That was Bankruptcy Legislative Reforms Committee, BLRC, under the chairmanship of Shri T.K. Vishwanathan. And this committee was to work on the legislative reforms which was to be done in the area of insolvency and bankruptcy. And uh, then on 4th November 2015, this committee gave its recommendation to Government of India regarding the one more new act, we can say a consolidated act, because we know that there was two separate acts for Mofussil and Presidency towns, and besides that SURFACE-I and RDDBFI, they were not working, and that is why they recommended to the government to have one new act, new code regarding the insolvency and bankruptcy matter. And that is why when they submitted the report to Government of India, government had gone through the report. They take over the suggestion which was given, and ultimately 2016 became one of the landmark year in the corporate history of India, we can say, as far as the recovery laws are concerned, whereby the government gave insolvency and bankruptcy court regarding the recovery of loans in the year 2016. So that is a little bit of history regarding IBC. Yes, Varun, please go for the next slide. Now, before moving further, once this IBC that was enacted by the Government of India, that is Insolvency and Bankruptcy Code 2016, many of the corporates, they did not find or they did not take this insolvency law in good terms. Means they were having their apprehensions regarding this. Many of them, they were even thinking that what is going to happen to us because of some stringent provisions and time bound provisions of IBC. They were thinking that they might be in trouble in the future. Means they have their own way of thinking. They have taken the loan, they have to repay, they have their own problems, and that is why there was a challenge regarding IBC before the court, challenging the constitutional validity. And the landmark case we can refer here, that was Swiss Ribbons Private Limited and another versus Union of India. Now, this is a landmark case which challenged the constitutional validity. Now, if you are well aware with the financial laws, you must be knowing that even when SURFACE-I Act 2002 came, then also some of the people, they went to the court. The famous case of Madhya Chemicals versus Union of India. There also many of the people, they went to the court, and court upheld the validity, constitutional validity of SURFACE-I Act. Similarly, here also court upheld the validity of this IBC, and one of the out of the so many issues, court discussed all the issues. Two of the most important issues I am taking, for which the court upheld their constitutional validity, along with the constitutional validity of other things. The first one was regarding the position of financial creditor and operational creditor. Now, when we move towards the next section of our discussion, we will go into detail about the financial creditor and operational creditor. Right now, we can understand financial creditors. Simply, financial creditor means the lending institutions who have given the loan, and operational creditor means the suppliers, government, and employees on another side. And when we again go into the depth of IBC, we will come to know that financial creditors, they are having important status in the committee of creditors. Means they are having the voting rights in the committee decisions, and not the operational creditors. And that is why it was challenged before the court that this discrimination between financial creditor and operational creditor that violates the provisions of Article 14 of the Constitution. Now, the thing was before the court, and the court upheld the validity of the differentiation between the financial creditor who are having the voting rights in the meeting and the operational creditors who are not having the voting rights, by saying that financial creditors they are the best persons who can assess the viability and feasibility of the business, because ultimately they have given the loan only after knowing the viability and feasibility of the business. As far as the operational creditors are concerned, they are most of the times they have nothing to do with the financial position. They are merely the suppliers or other stakeholders, and that is why whenever we have to assess the viability of the business, uh, the viability can better be assessed by financial creditor, and that is why the court said that IBC has the provision regarding the voting rights of financial creditor is not going to discriminate the operational creditor against the financial creditor. So this provision was upheld. And secondly, as far as the distribution of assets is concerned, at the time of liquidation of the corporate debtor, and this liquidation comes into picture only when all the uh, measures for the revival of the business, the resolution plan, it could not succeed. Only then the company go for liquidation. That is, the assets are to be sold, and the creditors, they are going to be get back their money. For this, Section 53 of IBC, that was challenged, and uh, the challenge was on the ground that operational creditors at the time of liquidation, their ranking in the payments is much lower in comparison to other creditors. That is, once the financial creditors are paid, only then operational creditors, they are going to be paid. This thing again was challenged, the same ground, that is violation of Article 14. And again, the Supreme Court said that as far as the repayment of financial debt uh, is concerned, they said that since the financial creditor infused the capital in the economy, stray, uh, just put stress on these words, that financial debts are essential to infuse the capital to the economy. Means this shows the importance of financial creditors and lending institution. They are the persons who are infusing capital in the economy, and that is why uh, there is nothing unconstitutional when the financial creditors, they are at priority at the time of repayment of the loan and other payments. And that is why uh, when, according to the provisions of IBC, at the time of liquidation, when the operational creditors, suppliers and all, their money comes only after, once the financial creditors, the lending institutions are paid, the court says that there is nothing unconstitutional about that. So because of this case, we can say that court has also upheld the constitutional validity of in Swiss Ribbons Private Limited versus Union of India. Yes, Varun, please go to the next slide. Now the next thing is that IBC applies on whom. Uh, as far as the IBC is concerned, application is concerned, uh, it applies for company, limited liability partnerships, corporate debtors, partnership firms, proprietorship firms and individuals. That is, whether it is an individual or whether it is a company, it applies to all these persons. Secondly, it relates to all the methods, whether it is for insolvency, whether it is for liquidation, even if the liquidation is voluntary, and for bankruptcy, according to section 2. So again, we can say that in nutshell, we can say IBC applies on all, irrespective of their business position. It applies on individuals as well as to companies. Obviously, whether it is your partnership firm, proprietorship firm, LLPs, and all that. Charger. So it applies to all these, and even the guarantors to the corporate debtors. Yes, Arun, next slide. Varun. Yes. Now, coming to the next part, that is here, as far as the topic for today is concerned, we are discussing the insolvency of corporate debtors, and that is why we are going to discuss about the corporate insolvency of the corporates. That is popularly and commonly referred as CIRP, that is Corporate Insolvency Resolution Process, CIRP. Now again, I am repeating that once anybody is insolvent and this IBC is invoked, it can be invoked for corporate insolvency resolution process, that is CIRP, that is for corporates on one side, and at the same time, the provisions of IBC, they also allow the resolution process for individuals, sole proprietorship, and partnership firm. So, since our topic relates to corporate insolvency, we are going to discuss about this in detail, that is CIRP. Now, before starting, the first important thing is that what do you mean by CIRP, Corporate Insolvency Resolution Process? Now, as we discussed so far, that the provisions of Insolvency and Bankruptcy Code, they provide opportunity, and just see how well it is balanced. It provides opportunity for both, whether it is your lender or whether it is borrower. For lender, they are having the chances to get back their money, and for the borrower, they are having the chances to revive, to survive in their business. And that is why under CIRP, the thing is that such kind of resolution is worked out, whereby the focus is on revival and survival of the business, instead of shutting down on the business. That is, the business is also survived. That is, such kind of resolution is worked out for that corporate debtor, so that the business can also survive, and at the same time, the creditors also get back their money. And that is why this initiation of CIRP under the provisions of IBC, it can be done either by financial creditor. Financial creditor here means the lending institution, banks, and it may be a secured creditor, it may be an unsecured creditor, or it can even be a decree holder. So all these categories, they comes under financial creditor. They can move, they can initiate for the CIRP. Before moving further, one more important thing is that after the amendment, after adding explanation to section 5 clause 8F, now even the home buyers who, although have not provided any finance to the corporates, then also after the amendment in 2018, even home buyers, they are also at par with the financial creditor. And these home buyers, they have also been given the status of financial creditor, and the way any lender can drag the corporates for the recovery of the loan. Similarly, home buyers, uh, and we know, all of us, we know the troubles of the home buyers. They give their money for the booking of the flat and all that, and for years and years, many times they don't get their money back, nor they get the possession of the property. And keeping the worries of home buyers in mind, uh, and there are some judgments like JP Infratech and all that. Uh, in light of all this, there is amendment done in section 585 clause 8F, and after that, even the home buyers who have booked their property with some builder, they are also now considered as financial creditor, and because of that, even home buyers can now drag these builders to the court if any builder has not given the timely possession or has not uh, uh, repaid the money to these home buyers. Second is operational creditor, that is the suppliers who supply essential to the business houses, then employees who work for the business houses, and the government who has to recover their taxes. So financial creditor, operational creditor, and again the most important thing for which we also discussed, that was corporate debtor itself. That is the business which is in trouble, the corporate debtor, they themselves can also initiate the process of CIRP. Now, how they are going to do? As far as the financial creditor is concerned, uh, any financial creditor himself or jointly with other financial creditor, they can move to the adjudicating authority, that is referred as double AA, which is NCLT, National Company Law Tribunal. So whenever anybody has to, any financial creditor, they have to get back their money, they can file the application before the appellate, before the adjudicating authority, NCLT, and NCLT is going to decide, that is accept or reject the application. That is how they can initiate CIRP. As far as operational creditors are concerned, before initiating the proceeding, first of all, they have to they have to serve a demand notice to the corporate debtor regarding the supplies. Now, who is the operational creditor? Mostly they are the suppliers. For any business, we know when they run, they need raw materials, essential supplies, water, electricity, lot of things as their daily requirements. And suppliers, they supply, and many of the times their amount is in crores of rupees. So these suppliers, although they have not provided any finance to the corporate debtor, but still their money is involved, and that is why they are also given the fair chance to recover their money, to initiate the proceeding. So they can go for if any operational creditor has to recover their money, they will have to serve the notice to the debtor, and corporate debtor within 10 days they will have to reply. And if the debtor says that if there is any dispute regarding the money, then first of all the dispute is going to be settled before the supplier and the corporate debtor. And till the dispute regarding the payment is not settled, uh, uh, this application regarding CIRP is not maintainable. Yes, Varun, next slide, please. So if there is dispute, the application cannot be succeeded. But in case there is no dispute regarding the payment, then NCLT is having the 14 days time within which either they are going to admit this CIRP or they are going to reject this application of CIRP. The last category who can initiate, that is corporate applicant. Corporate applicants, obviously they are the corporate debtor itself. They can also go for this. The only thing is that they can file the application for moving for this resolution process by passing a special resolution to that effect. So once they will have to pass the special resolution within their company, and after that, once they have passed the resolution, they can go before adjudicating authority, National Company Law Tribunal, which will be having the 14 days time. They can admit or they can reject their application. So these are the things which are to be done for initiation of insolvency process. Yes, next slide, please. Now, the next thing is, now we know that who can or who are eligible for this CIRP. Next thing is, it can be filed against whom. Now, as far as the provisions of IBC are concerned, resolution plan can be for individuals, for partnership firms and all. But as far as this CIRP, because we are focusing on corporate insolvency, and that is why when you talk about CIRP, that is corporate insolvency resolution process, it can be, this process can be initiated either against the company or it can be against the limited liability partnership firm. Mind you, partnership firms are not covered under CIRP. So either it will be a company, and if it is not a company and it is a firm, then which firm? The firm LLP which has been registered under Limited Liability Partnership Act 2008. So it can be filed against company and the limited liability partnership. One thing which the code has specifically mentioned, or they have made the exclusion, that is foreign entities, they are kept out of the purview right now. So against the foreign entities, we cannot initiate CIRP. And secondly, the financial service provider to any corporate debtor, like your housing finance companies, various and other NBFCs and all that. So against these financial service provider also, the proceedings of CIRP cannot be initiated. Yes, next slide, please. Now, one of the most important aspect about this IBC code, for which it is much praised, or speciality or beauty also we can say of IBC, that is regarding the time limit of this code. As we know that in each and every field, we always have the law. Even in the financial sector also, there are so many laws, recovery laws also, as we discussed just now, like recovery of debts due to banks and financial Institution Act 1993, then SurfaceI Act 2002, and so many other laws. The thing which makes IBC unique, because laws were already there and even before RDDBI and all that, the persons were having the option to even file. Civil remedy was always there to file a civil suit in the court and get back their loan. But the thing which makes IBC unique, that is the time-bound resolution. Generally, as such, there is no time limit in most of the other laws, recovery laws I am talking about. And that is why when you talk about filing the civil suit for recovery of your loan amount, we know that 20, 25 years, 30 years uh, time, most of the times it can be taken. That is the usual system for the recovery. Even in surface I as such, most of the things there was no time limit. Same for RDDBI. And that is why, as far as IBC is concerned, we also say, and it is part of their objective and preamble also, that IBC goes for a time-bound resolution. It is not that today I am going to file for IBC and I will have to wait for 5 years, 10 years, or 20 years to get back my money. If that is the thing, obviously IBC is not going to serve its purpose. And that is why it is very clear time bound limitation is there, whereby within 180 days, again I am repeating, within 6 months, 180 days from the admission of the application for initiation of CIRP, this process is must to be completed. 180 days is the time limit. Just see where decades were taken for the recovery of loans and years for the recovery. IBC, it just gives you 180 days either to go for the resolution, to revive or survive your business, or to go for liquidation. Whatever you have to do within a period of 180 days only. And that is a specialty, we can say, regarding IBC. At the same time, because many times because of any unfortunate delay, circumstances are not in our control, even if extension is required, then the resolution professional, that is the person who who works out the resolution plan and manages the corporate debtor during the time of insolvency proceedings, he has to file an application to the adjudicating authority to seek the extension. Uh, but for that also, the committee of creditors, that is financial creditors, they should pass a resolution by 66% of the voting share. So committee of creditors, if they pass the resolution and if they agree, mind you, it is in the hand of committee of creditors. If they agree, then only they will pass the resolution, voting share of 66%. Then once this resolution is passed, then an application can be filed before NCLT. And after that, the extension for these proceedings, it can be given for a maximum period of 90 days, uh, and that too only for once. So 180 days, and if extension is given, 90 days, and that too once only. So by that time limit, we are bound to complete this resolution process. Yes, Varun, next slide, please. Now, next stage is once your adjudicating authority, double A, that is National Company Law Tribunal, they have admitted the application for the process of resolution plan. The first thing which is done, that is a moratorium. Moratorium, for layman, in very simple words, we can say that it is a sort of stay over all the things. Means during this period, nothing is going to be done, and status quo is going to be maintained. Once there is admission of this CIRP, NCLT is going to declare moratorium, and publicly it is going to be announced that this corporate debtor, this company is under moratorium, and so that the common man also come to know that IBC proceedings are started against this company, and there will be a call for the submission of the claim. If anybody is having any claim due, they can ask for it, because now it is publicly announced. Secondly, there will be an appointment of interim resolution professional, that is IRP, and this is the most important person. Whole of the success of the CIRP, in a way, it depends on this person, that is IRP, interim resolution professional. He is the person who is going to manage the affairs of the company during moratorium. He is the person who is going to work out for the resolution plan, and he is going to be the ultimate person for deciding the fate of the company, whether the company can survive or whether the company is going to go for liquidation. So there will be an appointment of interim resolution professional also. And then the next thing is that this moratorium will be there till completion of CIRP, means the stay for which we are talking about. This will start from the day the application, that is admission of CIRP is there. From that day till the completion of this process, this moratorium is going to be there. Yes, next slide, please. Now, the next thing is what exactly happens during the moratorium. As you can read also, no suits are to be filed against the corporate debtor. That is very important, because if the suits are still going on, it will be difficult to carry on the process. Then the corporate debtor, he is not in position now to dispose, to sell their assets, because if it does so, the purpose of IBC is going to be gone. Then if you have invoked IBC, obviously surface I is not going to work. Then there cannot be any recovery of the corporate debtor's property. Then there will be no suspension or termination of any license, permit, registration, quota, concession, clearance which have been given by the competent authority. As we know, for running a business, so many licenses are required to be taken, permits are taken, registration is done. So there will, since we said that there will be suspension of the activities, stay, but it doesn't mean that there will be suspension of the license or permit also. And there will be at the same time no termination of the essential goods or services to the corporate debtor. Means when moratorium is there, it does not mean that the business is ended, and day-to-day activities are still going on to carry on the regular business. For that, if they need any essentials supply of goods and services, there will be no suspension or termination on the supply of these essential things. So that is also going to be there. Yes, next slide. Now, as far as this interim resolution professional is concerned, once he is appointed, in the first meeting of committee of creditors within 7 days, if 66% of the committee of creditors, that is financial creditors, they want to continue with this interim resolution professional, the same IRP, interim resolution professional, he will be the final resolution professional. Means the same person, he is going to continue doing the same thing. So that is an important aspect, that the same IRP, he can be a resolution professional. So in the meeting of COC, Committee of Creditors, if they want this interim resolution professional to continue his services, he can do so. At the same time, if they want to remove him and appoint a new resolution professional, they can do so. So that is the provision regarding appointment of IRP or RP. Now, in very precise manner, we can say what these IRP and RP they are going to do. Broadly, as we discussed, they are going to see that some resolution plan is worked out so that company can be survived. If not, company is going to be liquidated. For that, whatever steps they are required to be taken, they are going to be taken by IRP or RP. So point wise, we can say they can manage the affairs of the corporate debtor. And one thing here which is important, that is going concern concept under section 20. Now the focus of IBC is the maximization of the assets, and that is why the IRP or RP, they have to ensure that even if they have to liquidate the business should always be in a running condition. Means it doesn't mean that today any application is filed and today we are going to shut down the business. That thing is not going to be done. It is never to be done. And that is why IRP or RP, they have to ensure that this business, it should always be a going concern, because obviously running business is going to fetch more value in comparison to a business which has been shut down. So that is why the focus of RP, it is always to have a going concern business. Means a business should be going on, even if they have to sell, it should be in the running condition. Secondly, all the powers of board of directors or the powers of the corporate debtor, they are suspended during moratorium, and all these powers, just see the importance of IRP or RP here. The powers which are exercised by the board of directors, now these powers, they are going to be exercised by this resolution professional. Besides that, all the outsiders, financial institution and all that, they will also have to act on the instruction of this resolution professional. Besides that, this IRP, they is going to act and execute all the things for the corporate debtor. That is, he will work on behalf of the corporate debtor. Then he is going to determine the financial position of the corporate debtor. He is going to constitute a committee of creditor, and he will going to have the meeting also of this committee of creditors. Next slide, please. Then the main thing which, besides the things which we discussed, he has to preserve and protect the assets of the corporate debtor. He will keep in the custody and control of the assets of the corporate debtor. He represents himself on the part of the corporate debtor. He will constitute the committee of creditors. He will convene the meetings for them. Besides that, he will also invite prospective resolution applicants to submit a resolution plan. If anybody wants to give his own plan, he is going to invite the resolution plan from them. Then comes the important role, that is, he will present all the resolution plan, whatever plan he is working, all the plans which he is receiving, he will work out on all these resolution plan, whether the company can be survived, whether company needs liquidation. He is going to work on the resolution plan. And then the most important thing which starts, that is, he has to present all these resolution plan at the meeting of the committee of creditors for its approval. That is, whatever resolution plan he gets or he works out, he cannot finalize this resolution plan on its own, which simply means neither he can take his own decision regarding the revival of the business, nor he can decide on his own to liquidate the business. All the resolution plan, they are to be discussed before the committee of creditors. They are going to discuss, and if the committee of creditor is not having any objection regarding the resolution plan, it can be for the liquidation, or it can be for the continuance of the business as well. So if committee of creditors approve this plan, then it becomes binding on all of the stakeholders, and moratorium uh, once the committee approves this plan which has been put by resolution professional, then this plan is going to be uh, put before the adjudicating authority. Just see the stages. Resolution plan has been prepared by whom? Resolution professional and resolution applicant. Then final approval, that is by COC, Committee of Creditors, that is financial creditors. Once the financial creditors, Committee of Creditors, they don't have any objection, then it is put before the adjudicating authority, that is NCLT. So now the ball is in the court of NCLT. They are going to decide whether they have to approve it or not. If they approve, then it becomes binding on all the stakeholders, whether it is government, whether it is suppliers, creditors, any of the person, or even the corporate debtor. And if the resolution plan does not work out, or NCLT is having some objection regarding it, obviously it has got the right to reject the same. Yes, next slide. Now, as far as the corona pandemic is concerned and its effect on the corporate insolvency is there, as we have discussed all of the things. Now, what is the effect of this corona pandemic on insolvency laws? That is the most important thing. And government has taken so many steps, as we discussed earlier also. As far as IBC is concerned, they have done few of the things. They have increased the threshold limit for default by corporate debtor. Earlier it was 1 lakh of rupees, means default exceeding 1 lakh of rupees, and anybody can go for insolvency and bankruptcy proceeding. Now this limit has been raised from 1 lakh to 1 crore of rupees. So unless and until your debt exceeds 1 crore of rupees, you cannot invoke IBC now because of this amendment by way of ordinance which came on 5th of June 2020. Secondly, they have also came up with one section 10A, which talks about restriction on filing of any application for initiation of CIRP of corporate debtor. As we know that financial creditor, operational creditors, corporate debtor, they can file the application for CIRP, but now the government has done away with it because of corona pandemic by inserting section 10A, whereby now nobody for any default, nobody after 25th of March for a period of 6 months or such further period not exceeding 1 year from the March 25, 2020 as may be notified. So the point is that during this corona pandemic for 6 months, obviously, which is going to end by 25th September, there cannot be any initiation of corporate insolvency, means nobody can knock the door of a tribunal for invoking the provisions of IBC. So in a way, a stay is imposed, we can say, regarding this. And if the situation does not improve further, that is beyond September also, then for next 6 months also, the same thing can remain there, that is stay on proceedings for CIRP. And the effect is that no application shall ever be filed for initiation of CIRP of corporate debtor for the said default occurring during the specified period. So during this 6 months, or if it is uh, this limit is increased for further 6 months, whatever happens during this period, no application will be allowed even after the end of this period. So that is the purpose of this amendment 10A. Yes, next slide, please. So this initiation of corporate insolvency suspension is there, and that is why the three section, that is 7, 9 and 10, whereby financial creditor, operational creditor and the corporate debtor himself could initiate the corporate insolvency. And now for these 6 months, or if extended for further 6 months, these sections are not going to work during this corona pandemic. Obviously the effect will be there cannot be any invocation of insolvency proceeding. Secondly, a non-obstant clause to section 66 has also been added, whereby the directors of the corporate debtor, they are also being protected by way of this non-obstant clause, whereby the resolution professional, because of this amendment, now even if there is any default against the director of the company during this corona pandemic period, just see, earlier if there was any default by the any director, then the resolution professional was having the right to take steps against him. But during this period, no action can be taken even against the directors of the company for any default if they have done during this period of corona pandemic, that is 6 months, or it is extended for the coming 6 months. Then at the same time, as far as the insolvency proceeding of personal guarantors is concerned, uh, uh, the amendment is silent regarding that, and that is why the proceedings, although it cannot be against the corporate debtor, the proceedings are still allowed to be done in case of personal guarantors. Yes, next slide, please. So now coming to probably the last part of this, that is this relaxed IBC. That was our topic also, face saver for Indian corporates. As we have discussed all the things right now, uh, because of that, now we are in position to say that this relaxed provisions of IBC, in a sense, they are face saver for Indian corporates for the obvious reasons that although IBC is not available to Indian corporates, and although the government is silent regarding the applicability of SURFACE-I and RDDVI Act, we can conclude that for recovery of loan, although IBC is not available right now, but at the same time, SURFACE-I Act and recovery of debts due to banks and financial institution, it is still available for the lenders for recovery of the loan. But again, the thing is, since they already lost their relevance and usefulness, that is why it is not going to work much, and that is why corporates they won't have any problem even if SURFACE-I Act and RDDVI Act anybody uses them. So there will be no IBC, and that will be a saving thing for Indian corporates. Secondly, obviously, since there is no CIRP for a specified period of time for this corona pandemic, 6 months, ending on the 25th September. If extended further 6 months, there will be no initiation of corporate insolvency resolution plan, and that is why it will be a breather for the Indian corporates, because it is a very tough time for Indian corporates. Their business are wiped out. They are in very heavy trouble. They are not able to survive. There are so many industries, mostly ruins. They are hospitality, tourism. Now just see any hotel owner, if they have taken the loan, all the hotels, even if the government allows, who is going to be there in the hotel for coming few months? So it is a very really challenging time for uh, all these corporates, and that is why uh, uh, this is a big time for these corporates. Because of relaxed IBC, it is proving to be a face saver for Indian corporates. And obviously the threshold limit, which was earlier 1 lakh of rupees, now it has been raised to 1 crore of rupees. Obviously, it is again a big relief for medium, small, micro enterprises. It is going to benefit them, because below 1 crore of rupees, nobody is going to be allowed to file any case for insolvency and all that. So now we come to our end of the topic. I thank you all for their attention to this webinar. Thank you so much, Varun, and all the participants of this webinar. Thank you. Thank you so much.
Yes. If anyone wants to ask any question, please post your question in the chat box, or you can raise your hand. So let me check this.
Sure.
I request that if anyone wants to ask any question, please post your questions in the chat box or raise your hand. Someone typed in the chat box, I have a question. Please post your question. What, so there is one question. What
Yeah.
does personal guarantor mean?
Personal guarantor means you must be knowing that whenever anybody applies for the loan with a bank, and especially in case of very big amounts of loan, and I think in general also, beside seeing the potential of the loan applicant, that is his income and his status and all that, the bank also says that you should have one guarantor also. Only then we are going to give the loan. So guarantor here means that if anybody, although who has not taken any loan, obviously because of that he is not a debtor, but at the same time, even if he has given any guarantee for any company or an individual, and if that company or individual fails to repay the loan, then even the guarantor is also going to be called by the lender to repay the loan amount.
Thank you, sir. If anyone want to ask, please ask it as soon as possible. So there is no new question.
Okay, okay. So I hope the students and all the participants they understood it quite well. Again, thank you so much.
Thank you, sir. Thank you for your valuable time, sir. Now we
Thank you.
will end the session. Thank you, sir.
Well.